to at least circumvent such actions. But I have brought a few speaking points, just kind of paraphrased a few of the from a first-hand perspective on really what happened. Obviously, I wasn't here for the pre-trial, so I wasn't able to really hear what was stated by Mr. Stephen. My apologies, I don't know his last name. But point being is, if I may, I just would like to add a few points.
Sure.
Much appreciated. So the first thing I did want to add was I have had no interaction with this individual, and I've never met him prior. In fact, just walking into the courtroom today, I was asked, I'm so sorry, I don't know your name. What was it?
Miss.
Thank you so much. I was asked by her, if I could even point her out. I was not able to because I'm still not even able to identify him, if not for him walking up here. So I just wanted to point out, I've never seen him before. In fact, just to today, I wouldn't have known his face if not for seeing him. But there is a few more points I wanted to add of just kind of a story of a kind of a play-by-play of how this did happen, just to give perspective. But in this case, essentially what was happening was I work at a place not too far from here. I wish not to state it based on the fact that he is in the room and I don't want any further retaliation. But essentially, I work very close by. My fiance and I live very close to my work, within about a mile. And we decided for my lunch break, which I'm actually on right now from 1 to 2 p.m., that we would take a joyride to Subway, which is like half a mile away, and then go to my house to eat the Subway, which we usually spend our lunches together. So in this case, she just happened to come pick me up from my work, which I can state just off the record, maybe when he's not listening. In this case, my 11-month-old baby was in the car, and in this case, because he was a little bit fussier normally, because it was her vehicle, my fiance came to pick me up. I do want to clarify, and because of that, my 11-month was a little fussy. I have a very good fiance. She's the mother of my 11-month-old, so she decided to sit in the back to be able to make sure that he's like kind of calm. So at that point, I drove to the Subway. Upon leaving the Subway and trying to go home, which would have put me on Livernois Road, driving northbound on the left lane. There are two lanes in which I noticed there was a red truck behind me that was driving within inches of me, which was Mr. Stephen, upon further clarification. Now, in this case, he rode behind me for about a quarter of a mile before he was enraged to the point where he decided he was going to try to overtake my vehicle or just get around traffic, which was trafficy, because I was going exactly the speed limit. It appeared to frustrate Stephen to the point where he tried to go around me. There's two lanes, one left lane that we were in, he was behind me, and a right lane to go straight. He attempted to overtake me, was not successful because there was so much traffic that even the right lane, he couldn't overtake me because it's not like there was a big gap between me and the car in front of me. He just tried to overtake me essentially, I don't know, for his ego or whatever the case is. Bear in mind at this point, there was no interaction. He didn't say anything to me, he didn't roll down his window. I couldn't even tell he was angry or at me. So at this point, we approach a light on Livernois Road, and it's the Kurtz Boulevard and Livernois Road light. At this point, the individual is in a straight lane. There are three lanes. One lane to go left, which I entered. He is in a straight lane to go only straight. There is also another lane that he came from just to get next to me. Our light turns green from a red light because we're all the first person at the light. Instead of going straight, he decides to make an illegal left turn at a straight lane. When I was supposed to turn left on the Kurtz Boulevard, I had to come to an abrupt stop with my 11-month-old baby in the car and slam on my brakes. My apologies for the frustration in that. To the point where Mr. Stephen decided that he would cut me off from a lane where he could only go straight, slam on his brakes. Luckily, that light you can't just go left at, you have to go straight a little, you have to go straight a little bit to go left. So by the grace of God, that saved me from him hitting my car for the first interaction. Now, past that point, we waited about 15 to 30 seconds for Stephen to either get out of the vehicle, express his frustrations, or maybe just he didn't see our car and wanted to go left. He did none of the above. He remained in his vehicle at a stop point with me behind him. At that point, I realized there could be a malicious intention behind Stephen. So I began to make my left around Stephen to go on to Kurtz Boulevard. I successfully made my left, and he remained in a completely paused position until I successfully made my left, in which he decided to rev his red F-150 truck to the point of trying to sideswipe me on my son's side and the driver's side. So me and my son, which he was in the driver's backside. So he attempted for a second time to hit my vehicle. At that point, Luckily, there was a little side shoulder lane, which honestly doesn't even make sense because it doesn't turn it into anything, and I was able to avoid him for a second time. At this point, I realize he has malicious intention for my life. Not just to, it's not road rage. He hasn't talked to me. It's not a matter of probably what you guys see all day, road rage. There has been no prior interaction to this point. At this point, I realized that to save my fiance and my son's life, I have to avoid this individual. So upon trying to flight and go away from this individual, still on Kurtz Boulevard, and try to go straight to avoid him, his truck was faster than my fiance's vehicle, in which case he was able to, for a third attempt, successfully overtake my fiance's vehicle where I was driving and come within a split second to a complete stop where I had no reaction time, as in he got in front of me with such little timing for me to react that I couldn't even do anything to avoid him slamming his brakes, coming to a complete stop, and causing an accident. Now, I wouldn't even call it an accident, an intentional destruction of property. Not only that, with bodily or intentional harm towards not only me, my 11-month-old baby, but my fiance as well. And one little point I like to add as well is, once again, throughout the whole interaction, he didn't roll down his window, he didn't come out yelling. It wasn't a matter of road rage. This is an individual who is not safe to be on the road. And me personally, the fact that I even had to be the unlucky family to come across his manic episode, or whatever you want to call it, I truly personally believe I was unlucky in this event. However, there is obviously a case where there is still an individual with a license who could potentially do this to another family. For the grace of God, luckily, my 11-month-old was not harmed. However, I would like to make sure that this does not happen to another family, which is why I wanted to speak today. That's all I had to say.
Thank you, sir. I appreciate you coming to court and placing that on the record. All right. If I could have the defendant and defense counsel return to the podium, please. All right. What, if anything, would you like to place on the record?
Your Honor, just that my client will agree to pay whatever reasonable deductible there is for this matter. Also, he does take full responsibility for his actions. He is remorseful. He apologizes to the victim, and I believe this will never happen again.
All right. Is there anything that you would like to say on the record, sir, on your own behalf?
Yes, Your Honor. I take full responsibility for what happened. I'm sorry that I did this. This will never happen again.
Okay. So this is a case where the court considered the fact that you had been given a plea offer by the city to disorderly conduct, but you additionally pled responsible to a civil infraction that added a number of points to your driving record. It was my recollection that you actually pled no contest, which makes sense because clearly an accident occurred here. And any statements that you make on the record in this court case could potentially be used against you in other matters related to a civil case. So there wasn't a lot of information provided by you during the plea process for that reason. And that's not anything you're being penalized for, but it is the way that the law works when you're going to plead no contest. I also took into consideration when we brought you back for sentencing the fact that if there was a victim, that victim may choose to make a statement, and they did. There may be restitution that's being requested, and it sounds like there could be, although it's not certain at this point what it would be, so I can't order it. I didn't send you for a full screening through the probation department, just because I didn't have a lot of information that you had other negative contacts with the criminal justice system. Really didn't even have a bad driving record. However, listening to the victim today and what they placed on the record here in the courtroom about your driving behavior on the road and the fear that it instilled in everybody in the vehicle, I'm wondering if it would have been a better idea to send you for that pre-sentence investigation. I'm sure if we had a big discussion about what everyone's impression is of behavior on the roadway, on that day you might disagree with how the victim has portrayed things. But at the end of the day, the whole episode just makes no sense. And why anybody would be operating their vehicle on the road with everything else that's going on all of the distractions, all of the people coming from different places, being concerned about different things, the driving behavior on this particular day, to the extent that you've acknowledged it caused a disorder in the public place, doesn't make sense. And I am concerned because it just could be one of those sets of circumstances where it appears that you snapped. Thankfully, the person that you caused the accident with, they did not. But things could have been much different, and I just am concerned without more discourse that I would be ignoring an opportunity just to make sure that in the future you would make a much different decision. I'm assuming at this point you'll still have a license. The court has no authority to take that away from you. And while you have points assessed, it doesn't look like it would lead you down a path where you would lose your license. So I think there would be a benefit to requiring some education, if nothing else, an opportunity for us to have fines and court costs paid, an opportunity for the people, if they're going to follow up and file a motion seeking restitution, to do that. But really just get you back in a position where you can be safe on the road. And if in the future there's something that causes you aggravation about the way others are operating their vehicles on the road, you would take a different course of action and avoid coming back to court for criminal charges. I am going to require in this particular case, given everything I placed on the record and the concerns that were shared by the victim, impose a term of probation. Will be short, but 180 days of supervision I think would be appropriate. It would provide for you an opportunity to take traffic safety class and an anger management class or educational component that's going to be 2 days in length. You'll pay fines and costs. The fine could be up to $500. I won't impose the max fine, especially because there could be restitution, which would be more important than collecting a fine for the court here. But it's a $300 fine that you'll have to pay, court cost of $150 in state mandated assessments. And then that careless driving ticket comes with its own fine that's separately assessed. I think it's $215. For supervision, you'll pay the monthly oversight fees, but you could be done with probation in as early as 90 days after I see that you've completed the 2 courses I'm requiring and paid the fines and cost. If you are required to report, the probation officer will indicate when you have to appear, and you'll do so here at the courthouse. Clearly, I don't want you to have any new negative contact with the criminal justice system, no new charges or convictions, and then there are other standard conditions of probation that will be applied. Do you have any questions about the sentence of the court?
No, Your Honor.
All right.
Well said.
Sure, and then the oversight fees, he'll just pay those as he goes because I'm imposing, they're $40 a month.
40 a month?
I'm imposing the 6-month probationary term, but the law requires that I take a look at it at the halfway point if he's met all of the goals I've set out for him. He could request early discharge, so I don't require all of the probation oversight fees up front in case he's done early. But the probation officer will go over all of that with you and make sure that you're aware of the process for requesting early discharge if you're eligible. Thank you.
Appreciate it.
Okay, welcome folks. Yeah, this is Judge McGinnis' courtroom, which I found the link for. And the Tamela Peterson bail revocation, or she is suspected of having violated her bond conditions. That is scheduled for 2:30 p.m. But I started earlier since, I talked to the people over at Click on Detroit, a local channel, and they are saying that, yeah, she sometimes goes live, and then sometimes she goes on lunch and does not come back online on a live after lunch. Sometimes she, by a case-to-case basis, turns off the camera. So this is a bit of a hit and go. And so I started as soon as I saw that the afternoon session that she actually live streamed the afternoon session. Local media does not have her permission to live stream or restream. Lucky for me, I'm not in Michigan, which means I do not know the reaction of the court if they find out I restream her live stream. But since this was so tight in time, I decided, yeah, let's go for it, and I will contact the court for the next date, which is in December. I believe December 1st. I will actually ask for permission to either record it or live stream it, and then we will see what the judge says. All right, so this afternoon session seems to be bail hearings and stuff like that. So let's just follow it and see what happens. But this Tamela Harris is scheduled for 2:30 p.m. Eastern Time. All right, let's continue. And yes, I am over at Rumble Studios.
Yes,
well, so this
Thank
is
you, Jeff.
25003269. The people of the city of Troy versus Zachary Allen Mills.
Fifth is a court of Macmillan County City of Troy.
Your Honor, Roy Johnson, on behalf of Mr. Mills, will you please state your name?
Zachary Allen Mills.
Remember
Right,
to
Mr.
hit
Mills,
the
are you
thumbs
still
up.
using a mailing address on Alter Road?
Yes, Your Honor.
Today is the date and time set for a pretrial, and it looks like we also have to address an issue with bond. Let's handle the pretrial first if we can. Is there a plea offer?
Yes, Your Honor.
Your Honor, there is a plea offer. I did realize after I sent it out, I utilized an older form. So I did get rid of that advice of rights form. I do have the new one saved, but I don't know if the court needs a new one to be executed in order to take the plea.
No,
Okay.
I think this is fine. It covers all the bases. We just made some adjustments. I think it was mostly to an area that doesn't seem to be applicable necessarily. So I think we should be just fine with this
Okay.
one.
It's my understanding that defendant will be pleading guilty to the added count of operating while visibly impaired, and then upon acceptance of that plea, the state would request that the court dismiss the original charge of operating while intoxicated.
Okay. And is that the plea offer that's been made to your client?
That's correct, Your Honor. He has been advised of his trial rights and waive those trial rights and plead guilty to impaired driving.
All right. Just give me 1 second here, and I'm going to ask you to raise your right hand so I can swear you in. All right. Please raise your hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I swear.
All right, thank you. You can put your hand down. Did you hear and understand the plea offer that's just been outlined on the record? And did you have a full and fair opportunity to discuss your case with your attorney and review this advice of rights form known as People's Exhibit number 1?
Yes, Your Honor.
Did you go through the form and answer every question truthfully?
Yes, Your Honor.
Did you sign for the bottom of the second page after you reviewed the document?
Yes, Your Honor.
Do you understand that the maximum penalty for this misdemeanor offense, it could be up to 93 days in jail and or a fine of up to $300 plus court costs and state fees?
Yes, Your Honor.
In addition, the maximum term of probation that could be imposed would be up to 24 months. Do you understand that?
Yes, Your Honor.
Do you understand that if you're on probation or parole to another court or jurisdiction, a guilty plea in this case, it could negatively impact your status on probation or parole?
Yes, Your Honor.
Do you understand that you have the constitutional right to have a jury trial?
Yes, Your Honor.
Did you go through each of the rights you would have if you went to trial?
Yes, Your Honor.
And do you understand that if I accept your plea today, you will give up your right to go to trial?
Yes, Your Honor.
Has anyone promised you anything or threatened you in any way in order to get you to plead guilty?
No.
Is it your choice to do this today?
Yes, Your Honor.
Do you understand that if I accept your plea today, if you change your mind at a later date and would like to try to appeal your plea, the only way you'll get to do that is if you're granted leave to appeal from the circuit court?
Yes, Your Honor.
Do you also understand that upon entering a guilty plea today, you could give up certain rights or issues on an appeal that you would have otherwise had if you had gone to trial?
Yes, Your Honor.
Knowing all of this, is it still your decision to proceed with the guilty plea?
Yes, Your Honor.
Let me take your attention back to the date of the offense, August 3rd, 2025. On that day, were you in the city of Troy, Michigan?
Yes, Your Honor.
The ticket alleges that you're in the area of Rochester Road at or near Big Beaver Road. in the city of Troy on that day. Is that true?
Yes, sir.
Were you operating a motor vehicle?
Sure.
Prior to operating a vehicle, had you consumed alcohol or controlled substances? What did you consume?
About 4 beers at work. Then
Okay. Are the attorneys going to stipulate to the result of a breath? I'm assuming that this is a breath test.
Yes, Your Honor, 0.148.
Stipulate for the plea, Judge, yes.
Sir, how do you plead to the allegation that on this day in the city of Troy, you were operating a motor vehicle while you were visibly impaired by alcohol?
guilty.
Are the attorneys satisfied with the taking the plea?
Yes, Your Honor.
Yes, Your Honor.
I'm satisfied as well. I will accept your guilty plea. In exchange for that, I will grant the motion that the people have made to dismiss the original charge, which would have carried a higher penalty for you, specifically as it relates to your driver's license as well. Let's see what's happening here. I did get some information that you were called to submit to a drug or alcohol test on 9/11, and it was reported back to me that you failed to appear for that test.
I spoke to the gentleman at Adapt. His name was Michael. He,
Before you give me the explanation, which I'm happy to hear from you, but I just want to make sure you understand, as a rule, anytime someone comes in and there's a potential issue with their bond compliance, I have to put you on notice that the outcome of any discussion we have could mean I change your bond, or it could even mean that your bond gets revoked. Do you understand that?
yes, sir.
And because of that, that means you would always have the right to contest an allegation. You don't have to walk in and accept it. If you want to have a hearing on this issue, you could. Do you understand that?
Yes, sir.
I'm sensing that perhaps you want to give me an explanation about what happened. In doing so, that means you would give up your right to have a hearing. Is that what you want to do? Okay, what happened?
I was actually severely sick for about 2 weeks. The date that was outlined for me to go in to get tested, I was unable to financially. I spoke to a gentleman at Adapt. His name was Mike. He told me that they would reschedule that for me and that I would have to pay an additional fee to do the next testing. I would have to pay double.
Sounds very suspicious. Who is this person?
His name was Mike.
And he worked for the testing agency.
It was the phone number I was given.
Okay. I had a lot of thoughts about this. First of all, the magistrate has you testing once a month. I didn't know anything about what happened at the arraignment. That seems a little bit unusual for someone to only be testing once a month if there's going to be testing when they're placed on bond. But rather than make any changes, I just figured we'd come in today and see what's going on. But at this point, I think it's fair to say that the one time you were supposed to have tested in a month that you missed is now really not giving me any information about what's going on with that requirement that you refrain from drugs and alcohol. Now you've pled guilty, so I feel comfortable modifying the testing schedule just to ensure that we have you calling in every day and testing a little bit more frequently, because once a month is not necessarily going to give us a good, clear indication of if you're using drugs or alcohol, and it certainly won't help us if you miss that one test that you're supposed to go to. So I would like you to test today. The testing frequency is going to change to once a week. I'm a little bit concerned about a place that's telling you that they'll reschedule a test and then you can pay them double. I've never heard that before. But we'll have the bond compliance officer follow up with ADAPT just to see what's going on. And if it seems appropriate, you could switch a testing location and test somewhere else. Does that make sense?
A different company, Judge, right?
Yes.
Okay.
But at this point, we'll proceed to sentencing. You do have to be screened by the probation department. They'll set an interview date for you today, so you'll have that before you leave. You'll know to come back on that date to meet with the probation officer. They'll prepare a report, make sure that you're ready for sentencing. Your attorney, the prosecutor, and myself will all get a copy of that report, which may make some recommendations about sentencing. But we'll get to that point in a few weeks when you return to court for sentencing. Do you have any questions about the changes that I'm making to bond? All right, that's a different kind of play today.
Thank you, Judge. Have a good day.
Thank
Good
you.
seeing you.
Okay. Now, from yesterday, big thank you from the little Jen that could, who gifted 50 Swedish krona, $5 via PayPal. Thank you so much. That is so nice of you. She says, thank you for covering this case. My pleasure. I believe this case is more important than many people give credit, because these hyperbaric chambers, if left unregulated, they are lethal. Because this is not the only case where somebody is burnt alive in one. There was a case out of New York just a couple of months ago. There's this case, we have cases in Europe. So yeah, I believe this case deserves more attention. Now, as per usual, I'm starting out this case basically just me, as I have done happened with other cases, and then I suspect once it gets closer to trial, all the others will join. But I'm in it, and from more or less from the beginning. All right, let's continue. Now, okay, I talked, as I said, I talked to local media, and they say this judge might cut off the live stream on a case-to-case basis. So I'm not sure we will be able to see Tamela Peterson getting her bond revoked, but here we are, and it should start within 10 minutes. I do think that person in gray there is Tamela's attorney, so she might be here. Also, YouTube allows me to gift 10 free memberships per month.
25003419. This is the people of the city of Troy versus Robert Paul Andrews.
And I just gifted 5 of them. I hope you were one of them. Tomorrow I will gift 5 more.
Robert Paul Andrews.
Are you still using a mailing address in Clinton Township?
Yes.
Today's the date and time set for our first pretrial. How is your client proceeding?
Your Honor, at this time, we are asking the court if they would grant an adjournment on this matter. Mr. Andrews more or less is in the process of getting back his license, but it won't be approved until he's not eligible until after November 7th.
Okay.
If the court will be so gracious to adjourn the matter until after November 7th, that would be greatly appreciated.
Okay, any position from the people?
No, Your Honor, I think that's a reasonable request. That it would be able to allow for us to consider offering a better plea deal in this instance in the event that he does come back with a license and does not pick up anything else in the interim.
Okay. It seems reasonable. We'll set another pretrial, push out past the 7th of November. I did see, because your attorney filed an appearance, he requested that the arraignment was waived, which is fine. I just want to make sure that until I see you again, we've got some standard bond conditions in place for you. It's still a personal bond. You'll come back to court at your next court date. But I want to make sure that while on bond, no new criminal offenses and activity. Don't leave the state of Michigan unless you get prior approval from the court. So we just need to know if you're making a request to leave the state, and make sure all of your contact information is up to date with the court. That includes phone number and email, which I don't know that we have for you. So you'll need to provide that to the clerk's office, and any change in address would need to be reported as well. Do you have any questions?
No question, Your Honor.
Oh, and for you, one individualized condition, which is no driving without a valid driver's license and insurance, right?
Yes, Your Honor.
All right, thank you. We'll see you after the 7th of November.
Thank you, Your Honor.
Thank you.
Okay, another case handled.
25003010. People of the city of Troy versus Dylan Robert Landry.
Okay, so
Judge,
that's
the court will not want to have the city of Troy.
Daniel here for defendant. Good afternoon, Your Honor.
Good afternoon.
Now, to the state time comes of sentencing, Mr. Landry and I have reviewed the PSI. It's factually accurate. No additions, deletions, or corrections to be made. On behalf of the defendant, Your Honor, we both would respectfully request that the court adopt the recommendations as they are appropriate. And he is able to pay the entirety of his fines and costs this afternoon.
Thank you, I appreciate that. People, anything you want to place on the record?
No, Your Honor, thank you.
All right, sir, can I have you state your name?
Dylan Robert Landry.
Are you still using a mailing address on Canterbury Drive?
Yes, Your Honor.
You heard what your attorney has placed on the record today. The two of you had a chance to review the pre-sentence investigation report that was generated after your interview.
Yes, Your Honor.
And the information that's contained in this report, the background information, all of this looks accurate to you.
Yes, Your Honor.
They are making some recommendations for you that include a term of probation. With this type of offense, operating while visibly impaired, even though it's one that presents significant public safety concerns, it's not actually an offense that's defined as a serious misdemeanor. That means if I decide to place you on probation or impose jail time, I have to have a good reason why. In this particular case, I considered the fact that your content of alcohol in your body was well above the legal limit. You appeared to be appropriately reporting past use of alcohol or marijuana. At the end of the day, the substance use disorder evaluation that you were given, it didn't flag any sort of substance use disorder. Really, it's coming back to me with the recommendation that you participate in education so that you are getting all of the information that you can about the dangers of this type of behavior, but also things that you want to avoid so that you do not, at some point later on, have further issues with alcohol, substance use disorder. I did take into consideration the fact that you've been on bond, you've had some testing in place. I think we had one minor issue early on that was addressed, but no significant changes were made there. And then there was some information about any prior contacts with the criminal justice system. I think overall the recommendation is pretty fair. Clearly, I want to make sure that you're going to complete the educational component that's recommended, that you continue to maintain sobriety so that there's no concern about reoffending while you're under court supervision. And you have an opportunity to complete some community service, which I think is also appropriate given the nature of this particular offense that you pled guilty to. I am going to place you on probation for 9 months, a little different than what's recommended. It will be reporting, so you have to report to probation as ordered. You could be eligible for early discharge from probation, but you have to complete at least 1/2 of your probationary term. No violations for at least 90 days before you make the request. And you'll be asked to demonstrate how you've met the rehabilitative goals I've set out for you on probation. You can do this by submitting a letter or filling out the form asking the court to consider early discharge. Do you understand all of that?
Yes, Your Honor.
You'll also complete 15 hours of community service, which is slightly different, and can do that at a nonprofit agency of your choice. You'll also have to complete the weekend education program. I'd like that to be, you have to be enrolled within at least 60 days from today's date. No alcohol, marijuana, illegal drugs, or drugs without a prescription. I am going to continue the current testing schedule. We can take a look at that after 90 days to see if it should be reduced at that time. And the PO has the authority to do that. Fingerprinting has been completed. You have to continue to work and verify employment and then follow standard conditions of probation. For the financial penalty that's going to be imposed here, I do think it would be appropriate to impose a $300 fine. Court costs will be assessed at $300, $125 for your state mandated assessments. That assessment that you took, the substance use disorder assessment in probation, the cost for that is $110. Each month of probation is $40 a month. And the cost recovery amount that the city of Troy is requesting back pursuant to statute is $244.98. Any objection to that amount?
Go ahead.
So that will be ordered. It sounds like you've really come prepared to pay the fines and costs off today, which will be helpful for you in terms of completing the other conditions of probation. The oversight fees for probation. Uh-oh, forgot about this. Can you just bring him over here?
Oh.
Oversight fees for probation, you'll just pay those as you go on the chance that you're discharged from probation earlier than expected. I will send this out to front counter. They'll call you up to go over everything with you. They'll give you all the paperwork and then they'll let you know when your first appointment with probation is.
Thank you, Your Honor.
All right, thank you, sir.
Thank you, Your Honor. Mayor Pro.
You can, just a moment.
Which court? No! She turned it off. Oh. Alright, seems like she turned it off. Oh. Okay.
reasonable grounds on the
And
record
on
to
again.
support that decision because this is a drunk driving, but it's one with an accident where there was
Ow.
damage to somebody's property. So the jail sentence, if
This
the court
is
chooses to impose
Troy,
it, is appropriate as
which might
is,
be
just
Oakland
because of the
County.
reason
It's
that you're here, the
District
type of
Court
offense that you're here for, and
52.
the facts. There's a lot in this report. And I don't want to go into
She
a lot of
went off and
detail
on again.
because it's important for the court to have this information. It's not necessarily important for the public to have all of these details. You're 23. We're talking a lot about this case and the hopes that you'll have a jail sentence that will run
52-4
concurrent
District
with the
Court.
other jail sentence because you violated your opportunity to be on probation there with this case. What we're not talking about is the fact that there's still another case that's hanging out there that isn't going to go away, and you're going to have to address it once you're done with the sentence here, whatever that looks like, and the sentence for the violation. You understand that?
Yes.
It's going to take work for you to accomplish the goals that you want to achieve. It is very possible, but it's going to take some work. You have some history and experiences in your life. They probably have a big role to play in where you stand now with the use of drugs and alcohol. If you don't get to the bottom of what's happening and address those issues, it's going to be very difficult for you to get out of this cycle that you started at a young age. Do you understand that?
Yes.
I was confused at first why you were sitting in the jail and they were recommending a 60-day jail sentence when you live right around the corner and you definitely would qualify to be in a treatment court. And I really think something like that is going to be very appropriate for you. I don't know what will happen with your other case. Obviously, it's simply an allegation at this point. But if you have an opportunity to get some support in any way beyond the sentence that you'll serve in this case, I would encourage you to do that. So you have a much better chance of being successful at those things that you just listed on the record as goals for you. I don't know that it's really a position that we would be in at the court to provide an opportunity for that, because by the time you finish the other sentence, you'll have completed most of the jail that I could ever order in this case. And it doesn't necessarily fair to do that and then ask you to be on probation for 18 months to be in a drug court. But I'm putting all of this out there because at some point you will have to address an outstanding bench warrant. And whatever happens in that case, if you have an opportunity for something other than jail time, I would encourage you to take it. And if not, I would encourage you to get the support outside of the court system so that you can be successful. And there are many things that I know that you reviewed in this report that have been highlighted that I think are warranting some attention. I am going to follow this recommendation. At this point, 60 days of jail seems appropriate given the circumstances. I understand that this is a sentence that will be served concurrently to the time that you're already in the jail for the Oak Park violation. You have some credit here, so you are entitled to that, 18 days of credit. Restitution would be ordered. However, we don't have anything in writing to verify what the amount would be, but at some point that motion could come and you should expect to be asked to pay restitution or ask for a hearing. I'm not going to order all of these fines and costs for you to pay, but I will be ordering you to pay the state mandated assessment, the probation assessment that you were given, and you have to pay cost recovery, which is money that goes back to the city of Troy for the participation of the officers in the night that you were arrested. So they'll give you the total. When you're done with your jail sentence, you have to contact the court to figure out how to pay it and if you might be eligible for a payment plan. And at that point, there may be information about restitution, but you'll have notice of that. This is a jail sentence, so I have to advise you that you do have the right to appeal the sentence because it includes a term of incarceration. If you wish to file an appeal and you're unable to retain a lawyer, the IDSO Office of Oakland County will appoint a lawyer to represent you. I would just need you to make that request for a lawyer within 14 days of today's date. Do you understand those rights?
Yes.
Do you have any questions about your sentence?
No.
All right. That's it for today, so thank you.
All right, still waiting for Tamela Peterson to appear before the judge. Now, this is a general bond revocation, bond hearings, stuff like that. So can't say exactly when Tamela Peterson starts, but it's scheduled for now. Yes, this judge seems so calm. It's run of the mill. This is what happens in court on a Tuesday afternoon in Tamela, in Judge McGinnis Court, which is Oakland County District 52. I believe it's located in Troy. Oh no, don't tell me she turned it off again. No, it's... Okay, let's... She starts a new one. No. What's going on here? Okay. Don't know what happened with the live stream. This is her live stream, so I'm just... Okay, she turned it off. So I'm hoping she will turn it on again. So here you can see. Updating. Please show it. Please show it. This, who is there recording? Now, this is the court's own recording system. So I'm just updating here, hoping that she will go live. Because the Tamela Peterson is supposed to start right about now. Oh, come on, Judge. Go live. Go live. Oh, come on, Judge. Go live, live, live. Yeah. As of now, it seems like she turned the live stream off. Now, I knew this was a risk because I talked to local media, and it's a touch and go with, according to local media. She does live stream, then she deletes the live streams. So you better be there when she live streams. Sometimes afternoons she will not turn the live stream on after lunch. Sometimes it's a case by case basis if she has it on or off. So here we are, hoping she will turn the thing on again. Oh, please turn it back on. Please, please, please. Yeah, while we wait for that. Okay, while we wait and hope for this to come back on, the family has filed a lawsuit for Thomas Cooper. This is Thomas Cooper. This is the case I am covering, the hyperbaric chamber explosion case out of Michigan. The family has now filed a civil suit. NBC News reports the parents of a boy killed in January in a fire explosion inside a hyperbaric oxygen chamber filed a lawsuit Monday alleging the 5-year-old perished as a result of corporate greed. And hello, folks from Catnot Williams. Hello, folks. Thank you for joining. This is the hyperbaric chamber explosion case. And today is a bond hearing for CEO Tamela Peterson. We are waiting for Judge McGinnis to come back live. She was live up until a few minutes ago. Then she turned the live stream off. So while we wait, I'm going to read about the civil suit that is ongoing, parallel to this. The suit filed in Oakland County Circuit Court in Michigan calls Thomas Cooper's death the result of, quote, callous indifference to human life by the manufacturer of the oxygen chamber and the alternative medicine clinic that operated it. It said Thomas' parents, who lived in Royal Oak, Michigan, were not adequately warned that hyperbaric oxygen therapy could pose a serious risk of death should a fire break out, and said the hyperbaric chamber was designed without an effective way to extract someone during an emergency. Quote, the defendants knew with absolute certainty that if a fire occurred in one of its chambers, the patient inside would be burned alive with zero chance of survival, the lawsuit stated. James and Juana Cooper had taken their son to the Oxford Center in the Detroit suburb of Troy multiple times to receive hyperbaric oxygen therapy for sleep apnea and ADHD, according to the family's attorney, James Harrington. Quote, not only were there zero warnings from any of the defendants that are named in this lawsuit, it's actually quite the contrary. There was nothing but encouragement, support to get Thomas into a chamber for the sole purpose of profit, Harrison said Monday in his first interview about the lawsuit. Had they known and been given the choice, then they could have weighed whether or not this was something they would subject him to. Thomas was killed on January 31st when a blaze started inside the hyperbaric chamber where he was undergoing treatment. Harrington told NBC News that Thomas' mother rushed toward the chamber when the fire ignited, burning her arm in an unsuccessful attempt to save her son as he was burned alive in front of her. Thomas' family declined to speak about the lawsuit, which names 8 parties as defendants: the Oxford Center, its CEO and 3 of its staff members, the Oxford Kids Foundation, a non-profit associated with the center, Office Ventures Troy, the owners of the property that housed the Oxford Center, and Seacrest Industries, the manufacturer of the hyperbaric chamber. The death of 5-year-old Thomas Cooper was not a tragic accident. It was a foreseeable, inevitable, and virtually certain result of the defendant's callous indifference to human life. Young Thomas Cooper paid the ultimate price for defendant's corporate greed. The lawsuit seeks more than $100 million in damages, the defendants and their attorneys either declined to comment or did not immediately respond to requests from NBC News. Yeah, so this hyperbaric chamber. Now, it works like this. Person is put inside the hyperbaric chamber. It is then filled with 100% oxygen, and then it's pressurized. Meaning, you really can't get into it. And if a fire starts in there, you're burnt inside and outside, because the pressure makes the oxygen go in the lungs with pressure. There's no way out of it. And according to both the criminal suit, the criminal case and the civil suit, the defendants tampered with the maintenance logs. This hyperbaric chamber, according to the criminal case, hadn't been maintained properly since 2021. According to in the first initial hearings, which you can see here on my channel, I streamed it. The head engineer or technician experimented and made his own adjustments to the hyperbaric chamber. There was no grounding for the person inside, or even a grounding cable attached to the hyperbaric chamber in itself. With the result that if static electricity, then boom. So this poor boy, Thomas Cooper, was trapped inside a bomb. 100% oxygen bomb. And 100% oxygen is extremely flammable. Extremely flammable. Now, this case here is, I would assume, is a year to try. But when I heard about it, I wanted to cover it. So once something new happens, I will cover it. It might not be every week. It might not even be every month. Now, since my vacation, there was a hearing. So I still have a few things from that hearing to stream. I will do that tomorrow. And then it's another hearing scheduled for December 1st, which I will stream as well if I can. And so yeah, there's a lot of it. And today is Tamela Peterson's. She has an alleged bond violation, and it's scheduled for today, 2:30 p.m., which we are past. Sadly, Judge McGuinness cut off the live stream. And I don't know if she will come back live. I've been talking to local media, and they say it's a touch and go with Judge McGuinness and her live streams from the courtroom. She turns it off on a case-by-case basis. Her live streams are not saved, so they are deleted quite soon after the live stream ends. And sometimes after lunch, she does not live stream at all. So I'm hoping that she will come back live. As you can see here, this is an extremely sad case, and it should have more public attention. But as per usual, it's just me at the moment. So it's local media and me. And it seems like, well, she cut off the live stream about 15 minutes ago, and it doesn't seem like she is coming back, at least not for now, which is a bit infuriating. Now, Michigan is a bit notorious with not allowing recording or restreaming of their proceedings. I would hope that Michigan would go more of a Florida way, where it's open, let's view it, let's show it. But as for now, I know that local media has asked, and they are not allowed to restream it. I'm not in Michigan, so the judge's decisions does not really apply to me. Now, she chooses if she wants to live stream or not. Now, for the December 1st hearing, I will, via locals, I will at least try to ask for permission. Dun, dun, dun. Dun, dun, dun. Yeah, as you can see, she is not live at the moment. Keisha says, this case reminds me of the magnetic field association with the MRI machine. I don't know about that. Now, if you're close to an MRI machine, which is it's a huge magnet, and you don't tell them about your piercings, you will have a bad time. Because MRI machines will rip metal out of your body. Yeah, I wanted to watch this too. But it doesn't seem to... Yeah, it seems like she has gone offline, this judge, which is sad. I was really hoping to stream this hearing for you, because I'm very, very interested in what did Tamela Peterson do for having a hearing about a bond violation, and also what would be the result of it. Now, click on Detroit, which is local media, who also who covers this case. They will report on it, because as they told me, but they are not allowed to restream it. So I will wait for another 10 minutes or so, and if she hasn't returned live by then, well, I guess we have to wait for tomorrow. Yeah, the hearing, which I started yesterday, which is from a couple of weeks ago, it's a former employee, Tiffany Hosey, testifying about her her experiences as an employee at this Oxford so-called clinic. And we covered yesterday, we saw the direct examination in the hearing from the state. Tomorrow we will cover the cross-examination and of Tiffany Hosey. And so that is for tomorrow. Now, when we watched this yesterday, this former employee, there was some discrepancy regarding how much had she actually warned the clinic and talked about the dangers. And maybe a lot of it was internal dialogue, because her answers, it left stuff to desire. It left stuff to desire. So hearing because there are 4 defendants in the criminal case, the CEO and the 3 employees. So there will be 4 attorneys cross-examining her, and we will watch that tomorrow. Yeah, Click on Detroit has several past videos on this case, which I will go through in good order. Judge has not come live. So thank you for being here. Now, the first 45 minutes of this stream is other cases in Judge McKinney's court. So if you just joined, go back to the beginning and you can hear other cases and how she handles them. Today has been bond violation, DUI cases and stuff like that. Run of the mill, and how she handles herself in court. And my impression of her so far, very, very calm and by the rules. She's very by the rules. Not that she invents her own, but yeah, these are the rules. You violated it. This is what I'm going to do to you, and accept it. Dun, dun, dun. Dun, dun, dun. Please, Judge, come back live. Please, Judge McGinnis, come back live. I want to know what goes on with Tamela Peterson and her bond hearing. Hi, Fiery Red, saying hyperbaric chambers are crazy. Let's see. Imagine old copper diving helmets, but room size, thick walls. I can't imagine that force. Only dealt with them bringing ambulance patients for treatment there. Yeah, I mean, hyperbaric chambers is what you treat for diving sickness, for example. If you ascend too fast because of reasons, you have to be put in a hyperbaric chamber in order to repressurize your body, because if you will get bubbles of air in your bloodstream if in severe cases, and you might die. So they pressure you down to the depth that you ascended from, and then slowly but surely bring you back to surface level. But in hyperbaric chambers, in this case, they claim that the 100% oxygen pressurized helps you heal injuries, helps against apparently ADHD, autism, sleep apnea. It's a modern day snake oil. The studies on the area that I can find are more or less a circular argument. We use it, we see temporary improvements, therefore it works, more or less. And it's sold as a universal healthcare, a universal health remedy. Now, hyperbaric chamber treatment is not in Medicaid. Hyperbaric chambers are not within your insurance. So you have to pay big bucks. And there are, like this Oxford clinic, who preys on the desperate people, especially if it comes to ADD, ADHD, autism, severe cases, and all of a sudden, as a desperate parent, you hear that there is a remedy. And you try it because you're desperate. You pay them thousands and thousands and thousands of dollars. Luckily, this family did. And because of alleged greed, this Oxford clinic made shortcuts. They didn't maintain this hyperbaric chamber as it should be, allegedly. The patients inside the hyperbaric chambers are not grounded with there's no ground cable for the hyperbaric chamber in itself, according to the state's charging document. It was a death trap waiting to happen. And Thomas Cooper, 5-year-old with ADHD and sleep apnea, paid the ultimate price. He was inside that pressurized 100% oxygen when it ignited, and he was dead within seconds, probably. Yeah, as of now, I'm just rambling a bit. But it doesn't seem like this judge is coming back. If she does, I will make a video out of it. Yeah, this is an important case because there are hundreds of these clinics in the United States, unregulated, making these treatments. How many more are operated by people who does not care, who doesn't maintain the equipment, who use faulty equipment? How many death traps are there out there? Accidents waiting to happen. Hi, Jen the Couch Fairy. No, you haven't missed anything because the judge decided to cut the live stream. So the first 45 minutes is just other cases on the docket, and then she turned the live stream off. So I'm actually about to cut the stream myself because there's not much I can do here. there's not much I can do. So unless she comes back online, I will report from via local media what went on. And I will make a video out of it. And tomorrow I will go through the part 2 of the former employee testimony. But that will be for tomorrow. So folks, that is what I had for you. Sadly, I was really, really hoping to show this to you. I was really, really hoping to show this to you. Next live hearing is December 1st. I will then apply to the court to restream it. See if I'm lucky to get an approval to do it. But folks, everybody, thank you. Thank you for allowing me to do this. Thank you for being here. And yeah, so thank you. Now I am at Rumble Studios, streaming from Rumble Studios because StreamYard is crap. And I don't know how to do... I have video clips. So I can make a little outro. All right, folks. Thank you for being here. I will see you tomorrow for more hyperbaric chamber explosion case content. Okay. See you. Bye-bye.